All right, capital equipment. This is an interesting one. So I imagine you went through the rules today and you realize that there's certain kinds of assets that are never eligible for SR&ED. One, they got to be depreciable property, so land is never going to count. Even if got an experimental farm, it doesn't matter. You can't claim land. Building is the other big one. You can't claim a building or leaseholds in a building unless it's Reg 2903, what they call a prescribed special purpose building. As far as I know, there's only one in all of Canada. It's in Ottawa by Dalton Research. And if you read the definition of the Act, it's basically a clean room that has maximum, microns of dust per cubic meter. Roughly, it takes about $1 billion to $1.5 billion to build one of these facilities. So chances are, if your client's got one, you're going to know about it. There's only one so far. It probably doesn't apply, right? And you have to get pre-approval when you're building that they designated that, and then you're fine. But what they came in here is, Do Engineering was an engineering company that had a building, but part of their building they had a mobile trailer, which they bolted to the side of the building, and they used it as a lab, and then they could unhook it once in a while and go out. And they claimed that 100% SR&D asset because it's just used for testing. CRA argued, no, it's part of a building, so it's not in, and they argued, no, it's not a building, it's a structure attached to a building. So the court said, oh, is it a building, or is it in fact just a structure attached to a building, which is not a building? And they went into, what is a building? And they looked at all the things. It has no foundation. It sits on the ground like a mobile home. It's portable. It can be disassembled and constructed. And they go through, what's in there. Life expectancy, energy needs, things like that. And they basically said, it's not a building. It's another structure attached. It's SR&ED eligible. Okay? And that applies now in other CRA pronouncements that if I put a machine in and certain railings and stuff to protect me from the machine or a foundation thing, is that part of the building or is that part of the machine? Saying that's actually part of the machine. If I can argue it's necessary for the safety of the machine, it's not part of the building. So again, I can claim it as my ASA asset if I'm claiming capital. Aurora Marine, another one on capital. Now, this isn't particularly interesting, but it is just from a tax perspective if you're a tax practitioner. So one of the things is, as a tax practitioner, I realized that the Act says that there are certain types of expenses that you can never deduct for tax purposes, just because the government feels there's too much of a personal or abuse component. Things like club dues. So I can't deduct club dues. Even if I pay it for the owner, for his golf club, I don't get a deduction for that. Right? I just have to eat it on my Schedule 1. One of the other big ones is a yacht. Yachts aren't deductible. So a lot of it is something a boat or a yacht. A boat would be deductible, but if I call it a yacht, I can't deduct any expenses now. So this company does SR&D or Marine on a yacht and claims the yacht as an ASA shred asset, which technically, technologically it was approved. But CRA comes back and said, hey, well, the Act says you're not allowed to deduct a yacht for tax purposes, so we don't think you should be able to deduct it for SR&ED. And they go to court, and the judge says, well, this is a situation where the Act contradicts itself. We have an SR&D asset that you should be able to deduct, but at the same time, the Act prevents deduction of it. And then what he says is Section 37 overrules the other deduction. If it's an SR&D asset, then a yacht can be deducted and you can earn the credits on it. So just kind of a neat one where different areas of the Act conflict. The judge will tend to rule with the taxpayer where there's an unfair conflict or ambiguity in the law. Typically the ruling is to side with the taxpayer and get the law changed so it takes the ambiguity out. Because to have ambiguous laws is not fair to the taxpayer. Waxman, not really a strong case anymore, but an interesting one. It was very similar to Consultex, where a client had these cattle, and it basically not only claimed all the feed of the cattle, but actually claimed all the costs of the cattle that it was doing research on, $2 million, like as capital assets. And then it turned around and sold the cattle at the end of the day, so it made even more money. And it was really the same issue as in Consultex, where the CRA took an all or nothing and the taxpayer won. They got all the cost of the cattle in, despite the fact that they sold it. I'm saying this was pre the rules on disposition. So now they would have got the cost of the cattle in perhaps, but if they sold them, then they would have to repay those credits, so it would really just be a loan on the money. It wouldn't be as abusive as what happened here. The problem was, again, the CRA took an all or nothing approach, And the courts are tending to be stern with CRA. They're saying, look, if you want to take an all or nothing approach to something that we feel is abusive to the taxpayer, we're going to give everything to the taxpayer. And then you're going to be stuck with a bad precedent and worrying how you're going to change the law. Government assistance. This is a very interesting case in my opinion. A company called ComDev was a satellite development company.